The next thing to do is to advertise the grant of letters in a local newspaper and a legal periodical for 3 concurrent weeks. These advertising obligations are a huge benefit to our local publishing industry, and I'm not kidding. It is something that the publishing industry does reasonably well on, and seeing the bills for them in the states we handle, I see the cost of it. But it does, especially in the local newspaper. Some people read these things. Frankly, a lot of people read these things. And if somebody owed money, it is a way of learning that that debt exists and that it has to be taken care of, because then they can notify the executor to of the fact of the debt. The next task is to send notices to the beneficiaries. Pennsylvania requires that all beneficiaries of the estate receive notification that they are a potential beneficiary, so that they can make and take any steps necessary to protect their interests, to inquire about the estate, to inquire about that the property is being safeguarded and is being properly held. One interesting thing, too, that some of you may or may not know, many nonprofit organizations, and most notably churches, hire people to go through the Register of Wills offices every week to see, is there any bequest to that particular church within that diocese or within that geographic area. And because sometimes, again, there may be questions in wills about who gets what. And so the churches have people that go through each county's Register of Wills to look at the wills and see, is there anything that somebody was thinking of us about? And again, so that if there is a bequest or a potential bequest, the church can protect its interests for any potential payment. Filing certification of notices with Register of Wills. Register of Wills wants to be aware that the beneficiaries have been notified, and so there's a certification that needs to be filed with the register that those beneficiaries have received word. Sarah, I'm going to turn it over to you again to talk about notifying the banks and requesting the balance confirmation, closing accounts, and depositing into the estate account.
Okay, I just have one thing to add. When you probate a will, it becomes public. Part of almost like when a lawsuit is filed. Anybody can go into the Register of Wills and ask to see it, which is why you see a lot of very wealthy individuals will put most of their assets in a trust so that when it's probated, people don't know what they actually owned or had. So but it is part of a public, what's the word I'm looking for? Record, so that you could go in and anybody can look at your will once you die. As far as notifying the banks and requesting balance confirmations, the IRS and the Department of Revenue require that you have a formal confirmation letter from any institutions where the decedent owned or held accounts. So you have to write a letter and request that they give you this official date of death balance, and that's the number that you use on your death tax returns. You don't use, well, I have January 31st statement for the Wachovia account, and even though they died on January 24th, that's really not good enough. A good example of that was after 9/11. I mean, things tanked, so if you happen to be alive on September 10th, you can't use the values after that date. So you have to use the date of death balance on your death tax returns. So when you write a letter, they will request a short certificate, because banks will not just give out information to any Joe on the street. They have to know who you are and why you're asking for the information. And a lot of times they'll ask for a letter with what's called a medallion guarantee. For instance, I'm writing a letter on behalf of our executrix, and I say, hi, I'm Sarah, and I work at McAndrews Law Offices. Will you send me Mr. Doe's date of death values on his 10 accounts? They say, well, you know, Sarah, you're not on the short certificate. Mrs. Doe's on the short certificate. I have to have a letter that authorizes me to request this information, and a medallion guarantee is a stamp by a bank or a brokerage office that they have your signature on file somewhere. So that, I mean, it's a kind of a checks and balances that came about a little bit more after the Patriot Act in order, and with the identity theft the way it is today, all of those institutions are much more careful about who they send any information to at all. So you get these values, and then that's the information you'll use on the death tax returns.
Will you take a question? You've mentioned a couple of times value at time of death. Stock, for example, common stock in a corporation is worth, let's say, just the total value of the stock at date of death is worth $10,000. At the time of actual distribution of assets, that stock is worth $12,000. That $2,000 gain is just gain for the beneficiaries?
The question is, if stock goes up between date of death and date of distribution, is that a gain for the beneficiary? Yeah.
It will be when they sell it.
The same would be true of bonds that have not matured. The date of maturity is beyond the date of death. Therefore, the bonds aren't worth their full face value. We take it. So the bank or the broker has to determine what that value is. Is that right?
That is correct.
Yeah, I mean, basically, you know, estate tax, death tax considerations, you take a snapshot in time. What was the value when this person died? And they don't care very much whether it went up or down. And if people get a bequest under a will, typically they get a stepped up basis, so that if they later sell it, they are going to have less gain that they have to report if they've received a bequest under the will. That's one of the benefits of taking under an estate, because you get a stepped up basis in terms of tax considerations. Okay. Then upon the obtaining the information at the banks, closing the accounts, depositing into the estate account. Anything that we need to think about that process, Sarah?
No, just when you're closing the accounts, it's much easier to put everything into one estate account. But remember that banks only have that $100,000 FDIC insurance. So if you have large CDs or other, you know, savings accounts that are kind of spread out over several banks, you don't want to plop a bunch of money into one estate bank account. You're better off opening a discount brokerage account and putting it in a mutual fund where maybe the value at least earns a little money, and not keep it all in one bank account if it's pretty large.
And again, the primary consideration as an administratrix or executrix of an estate is the preservation of the value of that estate. There's real risk if you just let stocks or assets that can fluctuate remain as stocks or fluctuating assets. Because if that value goes down, then the beneficiaries could look to surcharge the executrix or administratrix for failing to preserve it. And I've had estates where the executrix absolutely insisted on maintaining stocks as stocks, and the stock went down precipitously. And they kept it that way, frankly, over my advice. And the beneficiaries came very, very close to petitioning the court to surcharge the executrix of that estate. So, you have to think long and hard, and it was done with the best of intentions, but you still need to think long and hard if you're going to keep assets in some sort of form, be it stocks or otherwise, that could fluctuate. The individual who's administering the estate also has to notify the Department of Public Welfare. I'm going to let Leslie talk first.